This series of videos on domestic violence is brought to you by the GBVO of the MRIC. One of the objectives of the GBVO is to inform you about your rights under the law of the Protection from Domestic Violence Act. Safety and peace are fundamental human rights as established in the Constitution of Mauritius, yet an alarming number of women are left in the dark regarding their human rights. Now is the time to say stop. Break the silence. Choose to leave safely and call the police. What is domestic violence? The law helps us understand what domestic violence is. So, domestic violence can be an incident or a pattern of incidents of controlling, coercive, threatening, degrading, and violent behavior, including sexual violence against their spouse, a child of their spouse, another person living under the same roof. Domestic violence acts include the following: physical abuse. This can be hitting, slapping, shoving, grabbing, pinching, biting, hair pulling, punching, strangulation, beating, inflicting wounds and blows. We then have emotional and verbal abuse. This involves threats, intimidation, harassment, stalking, ill treatment, insulting, brutality or cruelty, shaming, belittling, name-calling, jealousy, diminishing one's abilities, non-verbal coercion, harming pets, and destroying valuables and property of a person, isolation, or damaging relationships with his or her children. Moving on to sexual abuse. This can include forcing or coercing a partner sexually. This can range from an unwanted kiss to rape, threats to achieve sexual acts, or pressure one to have explicit photos or videos of them to be taken that the abuser may then use as leverage at a later stage. Sexual abuse also includes forced misuse of contraception, forced pregnancy or abortion. Last but not least, economic abuse. It is making or attempting to make an individual financially dependent on the abuser by maintaining control over financial resources. This can involve forbidding one to work or depriving necessities like food, clothing, shelter, and medication. Now is the time to say stop. Break the silence. Choose to leave safely and call the police. Protection order. A protection order is an order made by the court to ensure that the alleged victim, namely the applicant, is protected from domestic violence caused by the alleged abuser, namely the respondent. Who can apply for a protection order? Number 1, a spouse, meaning either a wife or a husband. Number 2, a person living under the same roof as the person causing the domestic abuse. How to apply for a protection order? A spouse or person living under the same roof as the alleged abuser can apply for an interim protection order at the district court through either the Family Support Bureau or the Family Support Services or the Brigade pour la Protection de la Famille. This service is free of charge. An interim protection order is an order made by the court that will be effective until the court hearing for the domestic order is heard. This will allow the court to protect the alleged victim if they are at risk of serious harm before hearing the matter in court. Here, the district magistrate may grant an interim protection order which takes effect immediately. In determining whether to grant, vary, or revoke a protection order, the court will consider the following factors Number 1. The need to ensure that the aggrieved spouse is protected from domestic violence. Number 2. The welfare of any child affected or likely to be affected by the alleged abuser's conduct. Number 3. The accommodation needs of the alleged victim, their children, as well as those of the alleged abuser and their children. Number 4. Any hardship that may be caused to the alleged abuser or to any of their children because of the making of the order. And number 5. Any other matter which the court may consider relevant. Occupation order. An occupation order allows the court to decide on the exclusive right to live in a residence belonging to the alleged victim or the alleged abuser, or both, who can apply for an occupation order. A spouse, meaning either a husband or wife, who has been the victim of an act of domestic violence and who reasonably believes that their spouse is likely to commit any further act of domestic violence against them. How to apply for an occupation order. If you are a spouse living under the same roof as the perpetrator, you can apply for an interim occupation order at your local district court through either the Family Support Bureau or the Family Support Services or the Brigade pour la Protection de la Famille. This service is free of charge. Here the district magistrate may grant the interim occupation order and grant the alleged victim, namely the applicant, the exclusive right to live in and occupy the residence. Where an interim occupation order is granted, a copy of the order will be served on the alleged abuser, namely the respondent, and it will require him or her to appear before the court on a particular date to prove why the interim occupation order should not be confirmed, varied, or discharged. An interim occupation order will remain in force until the court makes a final pronouncement on the application of the order. Where an occupation order is in force, either party may apply to the court for its variation, to change the terms, or revocation to have it set aside. In determining whether to vary or set aside the order, the court will consider the need for the protection of the alleged victim or their child and that it is in the best interest of the family. Tenancy order. A tenancy order is an order granted by the court to a victim of domestic violence providing the exclusive right to occupy a rented house. The court will decide which party will pay the rent. Who can apply for a tenancy order? A spouse, meaning either a husband or wife, who has been the victim of an act of domestic violence and who reasonably believes that their spouse is likely to commit any further act of domestic violence against them. How to apply for a tenancy order. If you are a spouse living under the same roof of the alleged abuser, you can apply for an interim tenancy order at the district court through either the Family Support Bureau or the Family Support Services or the Brigade pour la Protection de la Famille. This service is free of charge. This will allow the court to consider whether you are at risk of serious harm before hearing the matter in court. The district magistrate may grant the interim tenancy order, which is a temporary court order, and grant the alleged victim the exclusive right to live in the rented house. Where an interim tenancy order is granted, a copy of the order will be served on the alleged abuser. It will require the alleged abuser to appear before the court on a particular date to prove why the interim tenancy order should not be confirmed, varied, or discharged. An interim tenancy order will remain in force until the court makes a final pronouncement on the application of the order. Variation or revocation of a tenancy order. Where a tenancy order is in force, either party may apply to the court for its variation or revocation. The spouse applying for such variation or revocation will have a copy of the application to be served on the other spouse. In determining whether to vary or revoke a tenancy order, the court will consider the need for the protection of the alleged victim or their child, the best interest of the family, and any other matter which the court may consider relevant. What happens in court? The alleged victim here is referred to as the applicant and the alleged abuser is referred to as the respondent. The court can grant a protection order, a tenancy order, or an occupation order restraining the respondent from engaging in any act of domestic violence against the applicant. The applicant will state their version of facts under oath or solemn affirmation before the court. The respondent or their legal representative can ask questions to the applicant. The applicant can call witnesses to support their version of facts. The witnesses will be subject to questions from the respondent or their legal representative. The respondent will then depose under oath or solemn affirmation and may have to answer questions from the applicant or the applicant's legal representative. The respondent can also call witnesses to support their version of facts. After hearing the evidence, the magistrate may grant or deny the court order sought under the Protection from Domestic Violence Act. The law offers protection to all. Are you a victim of domestic violence? Domestic violence can be an incident or pattern of controlling, coercive, threatening, degrading, and violent behavior, including sexual violence committed by a person against their spouse. If you are a victim of domestic violence, you can go to your local district court and apply for an interim protection order through the Family Support Bureau or the Family Support Services or the Brigade pour la Protection de la Famille. The magistrate will grant an interim protection order if you are at risk of serious harm. The order will be served on the person abusing you, namely the respondent. The respondent will be asked to appear in court and prove why the interim protection order should not be confirmed or be set aside. If a person breaches any of the following orders under the Protection from Domestic Violence Act, an interim or protection order, an occupation order, a tenancy order, or an ancillary order, they will be committing an offense and may be arrested by the police. If convicted, the consequences are as follows. On a first conviction, a fine of no more than 50,000 rupees. On a second conviction, a fine of no more than 100,000 rupees and imprisonment for up to 2 years. And on a third or subsequent conviction, imprisonment for up to 5 years.
If you or someone you know is in danger, please contact the hotline for domestic violence on 139. For child abuse, call 113. It is free of charge. Or call the police on 148. You can also call the hotline 119. You can download the app L'Espoir. It will be of help to you. The Ministry of Gender Equality and Family Welfare is responsible for creating and implementing social policies and programs which promote women's empowerment, child development, family welfare, as well as the welfare of the community. For further details, call 206 3700 to reach the Family Welfare and Protection Unit. For family problems, call 119. For domestic violence issues, call 139. You may also visit their website and reach them by email. The Unit for Family Welfare Protection provides services to a network of Family Support Bureau and Family Support Services. They are located throughout the island. To contact your Family Support Bureau, you can visit them in person or call the number specific to your location. If you need help from the Brigade pour la Protection de la Famille, you can reach them by calling 208 12 12, or you can call 999 or call 148. Depending on your location, you can also contact the appropriate department for the Brigade pour la Protection de la Famille. In Rodrigues, the Commission for Women's Affairs and Child Development Family Welfare Consumer Protection and Price Fixing has a unit dedicated to family welfare, protection of women, and child development. This unit is responsible for implementing policies and programs to address gender-based violence and to promote the well-being of families. If you need help, call on 83242140. Call on 117 for domestic violence and child abuse. At the Malabar Family Integrated Centre, the Family Welfare and Protection Unit, the Child Development Unit, and the Brigade de la Protection de la Famille work together to provide holistic support and guidance to families. They operate in a one-stop shop for the service of soutien et de conseil aux familles. Their services are focused on meeting the needs of their clients.